So back in 2017, NSFAS beneficiary and Nelson Mandela Bay University student Sibongile Mani was supposed to receive just 1,400 rand from the fund, but instead 1.4 million rand was deposited into her account. By the time the error was detected, it was 73 days later, and the accounting student, we are told, had already spent more than 800,000 rand. Earlier this week, she was convicted of theft by the East London Regional Court. So much has been said about whether or not this was the right decision. So let's unpack this rather curious case. Bring in legal analyst Romeo Nthambeleni, who joins us via our telephone line this morning. Advocate Nthambeleni, it's great to have you on the program. Thank you so much indeed for making time. As I mentioned, so much has been said about who was actually in the wrong here. Was it NSFAS and its own dysfunctional mechanisms, for lack of a better term, or was it Sibongile Mani for spending money that wasn't hers? As a start, what does the law say?
Yeah, thank you very much, Ayanda, and good morning to you and the viewers. Look, it's very much clear. The law is clear in relation to what has actually transpired. It might have been a deposit that was made by error, as you have actually indicated. And then the moment the money lands into the account of the recipient, it becomes the responsibility of the recipient to return the money to its rightful owners. And, you know, we are saying that each and every individual knows the pattern of monies that flows into their account. And if there's an unusual amount that comes into your account, you yourself have the responsibility of actually tracking the owners of the money and refunding it back to the owners.
Yeah, and just a slight correction there. I said 1.4 million was deposited into her account.
14.
It was 14, right? Thanks for that.
Yeah, it was 14 million, yes.
And I wonder whether, I'm sure there is precedent, you know, it just didn't make headlines because I guess there wasn't as much interest. But typically, what kind of sentence does one get for something like this? And we'll speak about the mitigating factors in just a moment.
Yeah, look, I've once had a similar, case like this, I am aware when we go to court, the court gave us an offer of saying, the complainant want, their money to be paid back. If you pay back the money, the complainant is going to withdraw the case or withdraw the charges. And when you don't have, the money to pay back the money that you've already spent, the state has no option but to actually proceed with the case of theft against you, as we have already seen in this matter, that it's a theft case that was processed against them, and there was a conviction. And now, what is going to come after then is going to be a sentence. So I think this should send a very clear message that whatever that you receive, which is not a res nullis in law, you have to return it back to the rightful owners, because the moment you spend it, you become complicit. It's very easy, to spend money that you have received in your account. But you must know that the moment when the responsibility has shifted from the person who made a deposit to you, you have the responsibility of doing the right thing. We have already seen it now, that there is also issues of people that were claiming accommodation from NSFAS while they are staying at home. That is also unlawful and illegal.
Yeah, I mean, in that case, the example you've just cited, it's clearly easier, I think, to see that is fraud, right? You're saying you need something that you don't. What I think was most interesting about this is that Sibongile didn't apply for anything. She didn't ask for the money, so to speak. It came into her account, and, she went on to spend it. Another aspect worth unpacking is when sentencing proceedings get underway, could an argument around, I don't know, hypothetically speaking, poverty help her case in any way at all?
No, not at all. Because, look, the law is very clear when it comes to that. In terms of sentencing procedures, I think here the state will obviously argue for a custodial sentence, but I think it's going to be a non-custodial sentence. Why I'm saying that, because the money came unsolicited from the account, from the NSFAS account to the account holder, and then from there, the person was a student, and then whether the person is a first-time offender, and all those kind of things. If those things, but those boxes are ticked, I think a non-custodial sentence will actually serve as an example or serve as a deterrent, because a person under those circumstances, I don't think it serves any purpose to give a custodial sentence. So based on the mitigation factors, to say it's a student, and maybe she's still continuing further with her studies, will all actually help her, and it was a first-time offense, and the money landed into her account, and she was tempted to actually spend it, will not call for a custodial sentence.
Yeah.
But I think that will actually help in actually mitigating those sentences, because also in the case that I handled where I was representing a client, we also ended up with a non-custodial sentence.
Sure. I want to make sure we're all on the same page here, Advocate. Please help us understand the difference between a custodial and a non-custodial sentence very quickly.
Yeah, a custodial sentence is where you are sentenced to serve an imprisonment term in jail, serving time. And then a non-custodial sentence is a sentence where you serve when you're outside, so that maybe it can be a suspended sentence for a period of 3 years for you not being found into having committed the same offense. So I believe that is going to be actually the case. But the challenge is that she's going to have a criminal record, unfortunately, against her name,
Sure.
with something that could have been resolved from the beginning.
Very difficult to digest that. And in what ways, if any, can the banks be held accountable for any oversight, lack of performing their duties? I mean, does the bank walk out of this smelling like a bed of roses?
I'm not sure whether there were charges that were professed against the person who made a deposit. I've not seen the charges, the indictment that was actually brought by the state. So that whether there's another case that was brought by NSFAS relating to the person who actually made the deposit, which was a flaw or a mistake, which was done by the system. So I'm not sure on that line whether there are charges that were processed against them and how that is going to actually pan out. What we were aware of is the issue that was being dealt with by the recipient who received the money into their account and now is facing a criminal record against their name. And in terms of employment in South Africa, with a criminal record, it's another mountain to climb for you to actually look for an employment, and especially dealing with issues relating to theft. And theft is a serious offense.
Yeah, it's been a hot topic for quite some time, and as the dust settles, I imagine plenty lessons are being learned. Legal analyst, Advocate Romeo Nthambeleni, thanks very much indeed for your time.